What constitutes defamation?
Well, it'd be a false statement of fact that lowers the reputation of the other person. Difficult example, let's say, okay, I do not believe that the steak I ate was Wagyu. Well, it's a bit difficult, right? Is it a statement of fact or a statement of opinion? I can argue that it's a statement of opinion, and I can say that I came up to the opinion because I've had hundreds of Wagyu steaks. It lacked that distinct flavor, but you're not expressing it as a fact, right? You're saying that I don't think it is.
Today we have Ivan Lee, partner at PD Legal. He specializes in both civil and commercial litigation as well as a general litigation practice.
Make sure your criticisms are always anchored in facts. Don't speculate, don't express something as a fact if you don't know whether it's actually factual or not.
Welcome back to the show, Ivan. Second time around.
Today,
Today, what I wanted to just go straight into is what I've been receiving a lot of questions about in the last couple of months, maybe even years. Google reviews. And let me explain.
Okay.
So this could be a typical scenario where you're a business owner. You could be something as retail and and commonplace as a hair salon, maybe, or anything that is serving the mass market, car workshop, any sort of retail service or experience, or something that's a little bit more high level. We could be dentist, we could be interior designer, we could be accountant, or something a bit more professional in the higher in the food chain, or price point, if I could say. But the point is that business owners now very often, maybe even almost always, have some sort of an online presence. Okay, and let's maybe simplify it. Google presence, Google profile, right? Which allows people to leave their comments and feedback. And what I've been seeing, because of the inquiries that we get and the questions that we get, the problems that they encounter, people that encounter, bad reviews, false reviews, defamatory even, inflammatory, offensive, abrasive, aggressive, outright trolling even sometimes. So this is, what I've just said is experiences from the business owner's perspective. But sometimes it's also the perspective of the user. And you again have a spectrum, right? You have disgruntled, outright, unjustified comments made by an unhappy customer, up to pure matter of fact and opinion, and justified. And I'm trying to not use the actual terminology, but the actual fact that they're just stating. For example, I didn't enjoy my experience. I expected more. Nothing that is even remotely defamatory, or how should I say this, subjective. It's completely factual. And I've seen people on both sides of the fence, service provider and service user, both ends of the spectrum, whether they were justified, more justified and less justified. A lot of these people encounter situations where they rub each other the wrong way, even after the service has finished. And then there is now the very unpleasant topic of defamation. Can I take action? What is it that you've seen in the work that you've handled?
Well, I think it's precisely what you mentioned. I mean, the classes of people that you mentioned just now, interior designers, hair salons, restaurants, those are all clients that I've dealt with, right? And usually not on their end. Usually I would say most of my cases are for the publisher, the one that's posting the statement.
The customer.
The customer. And they've more often than not, their reviews seem honest, right? It's an opinion, factual.
And factual.
Well, yes. So I mean, if you say something like, I did not enjoy the food, right? I have restaurants coming after my clients for that.
Yes.
Right? And I think that is, free speech, right? That's clearly not defamatory. It's a statement of opinion, it's not fact.
So when would something be, what constitutes defamation then, to ask that question?
Well, it'd be a false statement of fact that lowers the reputation of the other person, right? So
in this case, it's the service provider.
Yes, so let's call the service provider the claimant, because that's usually how it works out in court proceedings.
The
service provider will be the one that sues.
Correct.
Right? And the person on the other end, we call him the publisher, the one that makes the statement. Right? So a Google review, Facebook post.
Claimant, publisher. Okay, good. What would be the criteria for something to be regarded as defamatory?
Well, so again, it'd be a false statement that lowers the reputation of the person on the receiving end. So lowers the reputation of the person, of the claimant.
Okay, so these, in a very simple terms, there are many other criteria.
Broadly, the statement has to refer to the claimant and has also to be published to a third party.
To a third party, okay. Yeah. So maybe let's go into that first, which is less interesting, I would say, and less contentious when we come back into the actual substance of the statement. Publishing, does that mean that if I send it to one person, would that be enough for publishing?
Well, it depends. If I'm sending it to the claimant directly and to no one else, then that wouldn't be considered publication. It would be considered publication, but the element is publication to a third party.
Okay.
Right. So if I am unhappy with a restaurant and I send them a private message, right? That's not defamation.
So that doesn't count.
That doesn't count. But if I send it to another person, a customer, that could potentially be defamation.
And certainly in the situation where I publish it to the general public through a
Yep.
Google review, would that clearly satisfy
Yes.
publishing to a third party?
Yeah, so I didn't really mention too much about the second two elements of publication and reference to a claimant, because in the context of online defamation, when we're talking about Google reviews,
Yes.
you're making the post on the Google page, which means you're referring to that business page, right? So that element will be made out. Publication to third parties will also be made out because Google reviews are public.
Would that also apply to things like Facebook posts or any sort of social media post? I'm
Yes.
posting on Instagram, I'm posting on Facebook, I'm posting on TikTok, a comment, and then that is something that will be automatically constituted as regarded as publishing.
Publishing, yes, but referring to the claimant, not so straightforward. So if you make a TikTok post about, let's say, a review of a restaurant, but you don't specifically mention the restaurant, you just say it's a Spanish tapas restaurant in Teluk Ayer, right? That might not be defamation because
There could be
which restaurant are you talking about?
But if you did it on the restaurant's TikTok channel and page, that would be.
Yeah. So if you leave a comment on their post, perhaps.
I see.
Easily referable to that restaurant.
So good. So we've taken last question about this third party aspect. How about WhatsApp groups? So you and I are in a group of 50 people, classmates or ex-colleagues or whatever, and then one of us says something about another person. It could be a business. Let's just stick to the business context, saying that this restaurant is lousy or this business don't use this interior designer. Would that also be publishing?
Yes, it would.
I see.
Yeah, as long as it's communicated to a third party and you know who the statement is made about.
Let's talk about now the elements, right? You said it must lower the reputation
of the claimant.
So this is where the fight usually is, right? One person will say, the publisher will say, it's a matter of fact. I'm just stating a fact, my opinion. We see this in our research very often, right? Where opinions sometimes can be regarded as justified, and there's also other defenses or justifications, right?
Okay, so usually that would be the first stage would be whether a statement is defamatory. Right? So in most cases, if you are suing someone, the statement would be more or less defamatory. Right? And then you move to step two. So on the publisher's side, do you have any defenses available to you?
I see.
Most obvious defense, justification. Right? Whatever I said is true.
That's one.
Yeah, so an example of that would be...
I did in fact find a bug in my food, an insect in my food.
Right? So that is fact. That's not an opinion because we can verify.
I have a photograph of it. Yeah, I have a screenshot.
Exactly.
So that's one.
So that would be justification. You have a full defense there.
Good.
Next one would be a fair comment or an honest opinion.
Are those two the same or are they separate?
They're more or less the same. You can think of it as the same heading, right? So that would be...
Example?
The food was bad. Right? So
are you entitled to say that?
You are entitled to say that, but that has to be based on actual fact, right? So if you say the food is bad, but you have never gone down to the restaurant, that's
you
not
need to
defense.
be in a position to make that comment.
Yes, and you sort of have to justify that comment as well, right? It needs to be grounded in at least some fact.
Yeah.
Right. So maybe we go
some evidence at least.
Yeah. Let's do a more difficult example. Let's say, I do not believe that the steak I ate was Wagyu. Well, it's a bit difficult, right? Is it a statement of fact? It's a statement of opinion. Right? I can argue that it's a statement of opinion. I can say that look, I came up to the opinion because I've had hundreds of Wagyu steaks. It lacked that distinct flavor, or the marbling of the steak was
clearly
not there.
Yeah, I took a picture and it's clearly not. Right?
Yeah, but you're not expressing it as a fact.
Yeah.
Right? You're saying that I don't think it is.
And you have a basis, you have a legitimate basis for that, for saying that. Okay, so that's the second one. Is there a third? Are there others?
Well, okay,
justification.
The others aren't very commonplace. So I mean, another defense would be privilege, right? So there's absolute privilege for things like making certain comments in Parliament or in court proceedings.
Okay,
right?
quite rare.
Quite rare.
We don't need to talk about.
Then
and that's called
absolute privilege.
That's absolute privilege.
Yeah.
Okay.
And then there's qualified privilege, where you make a statement where there's legal, moral, and social duty to make a statement. I think a common situation where it's serious arising would be employee referrals. Right? I am a former employer. I'm coming to you as a prospective employer. You ask me for an opinion on James as a potential candidate.
Yes.
I tell you, James.
He wasn't very good.
Wasn't very good. Always comes to work late.
Yeah.
Right? That is usually it will be a defense of privilege, qualified privilege, right? I have a duty to inform you of all these things, and you have a duty
I
to
see.
say
I have
that.
a duty to the person that I'm communicating this to.
Yes, as employer,
I
as a
see.
future
I see.
employer.
Okay. Are there any more justification, privilege?
Yeah, I mean, those are three main defenses. There is a defense of innocent dissemination, but that is we usually don't see it much.
How about situations where people repost, which happens enough?
Well,
And we don't need to go into real life examples because that's a bit sensitive.
Yeah, so if you repost, generally are taken as having made a statement,
I see.
right? So it gets a bit complex there. But if you make that statement, if you repost it, and there's an endorsement as to the truth of the statement, you can be held liable for it.
What if it's just a simple, what if it's a complete, literal, physical act of just reposting without saying either a thumbs up or thumbs down or any other sort of layer to it? Just simply repost.
Well, that would be considered as a new publication, right? But you might have defenses against it, but generally you're considered to have made a statement yourself.
Unless, in the ideal situation for the publisher, you repost it and say, I don't actually agree with this.
Oh, yeah.
Which is
That's fine, right? So there's a disclaimer there that you don't believe in the truth. This is just what some person said.
Yes.
It'll be hard for the courts to find it.
And on the flip side, if you reposted it and there is anything to show that you endorsed it, then probably not so good for you.
Exactly. If you say I knew it or I told you so.
Yeah, I told you so, and this is exactly what I think. Right?
Yeah.
Okay. That's a good start. Okay. Now let's stand on the side of the claimant. So say hair salon, interior designer, any sort of a service provider. This happens. I work very hard to build my business. I could be big or small. I guard and I protect my reputation very strongly because it's what we trade on, right? Especially in the digital world where people see the review and the feedback and the comments and the opinions before they even get a chance, maybe before they even make a decision about engaging you.
Yeah.
So in that situation, when you see a bad review, what would you, I wouldn't say advise, but what would you suggest that the business owner go through as a thought process before pressing the button and say, I'm going to sue that publisher?
Well, I think firstly you have to look at what you disagree with, right? Are you disagreeing with someone's opinion, or are you disagreeing with something that the publisher complained of that is untrue, right? If it's an opinion, then everyone's entitled to the opinion, right? Think twice about suing. But if it's a fact, right? Let's say the review says I received my coffee an hour late, right? And you have records to show that the coffee came after 5 minutes, right? That is something that you should go after because that's totally untrue. It's not representative of your business.
And we'll come to whether it is meaningful and worthwhile
Yes.
to actually do it later. But what you're saying is first find out whether there's a basis for it.
Yes.
Okay, so let's move on to the next one. Is it worthwhile to do it? This could be a longer answer or maybe there's no fixed answer, right? But what would you suggest a person go through as a thought process?
I think at the end of the day, it all comes down to money, right? You can look at your review page and you can see a number of stars, right? Someone leaves a bad review, you're unhappy with it, but how far are you willing to go to pursue it? Because you go through a court case, it's expensive, right? Another thing that I have seen some of this business doing is sending a letter of demand just to force the review out, even though they might not succeed in court. Usually a lot of reviewers would just remove the review.
Let's say it's an anonymous review. I put Charlie Brown. I'm saying that, or some other fictitious person, Mickey Mouse. How would you realistically, as the claimant, you can have a hunch because you can try to extrapolate and reverse engineer and say, I remember that day there was a very big argument in the restaurant. I remember this person maybe even saying, I'll make sure that your business closed down. Right? Let's just say that's the scenario. As a claimant from a legal perspective, how viable is it to pursue this? Maybe even send a letter of demand if there's no real connection with the publisher.
Well, okay, it's difficult, right? Because if it's a Google review by someone who intends to be anonymous, usually what you have is maybe just a display name and maybe if you're lucky, an email address.
If you're lucky.
You can send a letter of demand to the email address, but if that person is smart, you can't do anything with me because you have no idea who I am.
Yeah.
Right? So what recourse do you have? Maybe getting the information from Google, and that's not going to be easy.
So maybe, since we touched on that, leaving aside how difficult it is or expensive it is it even something that's possible?
Well, I think it is possible, but it firstly going to be very expensive, going to be time consuming, and there's no guarantees, right? Because whatever you register with Google might not even be true.
Okay, let's unpack this a little, and I don't want to sound too technical, but this is also something that I'm sure listeners or viewers will think about because they can access this fairly easily. Getting the IP address, getting the IP address of the person who filed or uploaded the comment in question.
Okay, so I'm not an expert on this topic, but I think there are ways to mask the IP address, right? So I don't know how conclusive the court will find the IP address, right, as being linked to someone.
Correct. This shouldn't be seen as an endorsement or training to teach people how to leave reviews without being caught. But really, this is what I say very often to people in general, friends and family alike, which is it's not difficult for a person to cover their tracks.
Not at all. Not
you should assume that difficult, if not impossible, to locate, identify, and connect the published comment with the person. And if that is the case, your entire exercise may already fail at the beginning.
Yeah, I would say instead of doing that, instead of spending money, let's say on lawyers or maybe tech experts to identify the publisher, lodge a report with Google. Right? I know Google removes fake reviews.
Yes.
I'm not sure if they remove reviews from anonymous people. I don't think they do. But I think if you can show that the review is not genuine, I think Google does actually remove those reviews.
Yeah, as a responsible sort of
service provider.
Yeah, service provider and administrator of this space. Right?
Yeah, I think I've seen multiple instances.
Okay, so still on the side of the claimant and the person thinking about whether I should file a claim, let's talk about steps and then cost. Leaving aside again whether it's worthwhile.
Okay.
But say the person has decided I want to try. People talk about sending a letter of demand or a cease and desist letter. Okay, that's one thing I want to talk about. And then what happens after that? If there's a bit of toing and froing, negotiating, defending, explaining, denying even, right? And if there can be some sort of bargaining to a resolution, that's the second. And then the third one, if resolutions fail or if a compromise cannot be reached, what happens then when an actual claim takes place? And the last one is, in the actual claim, how painful and time-consuming and taxing resource-wise is that? So let's start with the first. Everybody talks about this all the time. Cease and desist letter. Can you send this to this person? I think I know it's Mr. Ong who sent it, or Madam Lim who did it. I know for a fact. Or even if I don't, I suspect it is. Can you send this? Could you explain what does this cease and desist letter do? Is it some magical document that will scare the publisher into acknowledging their conduct, in your view?
Well, okay. So the way I see a letter of demand is a warning shot. Right? You are telling them what you're complaining about and the potential consequences they will suffer if they don't comply with a letter of demand. Right? So common things you see in a letter of demand for defamation, depending on how aggressive the claimant is, would be usually it starts with remove the post. Right? More aggressive would be remove the post and give me an apology. And then lastly, we have remove the post, give me an apology and pay me damages. Right? Compensation for my hurt feelings.
Also, maybe as well as my legal costs. Sometimes.
Yeah, sometimes. Yeah, sometimes you can do that.
You brought up some other issues we want to talk about, which is damages, right? Which is something that people read about all the time, but have no idea how it's actually estimated or calculated. We'll come to that later. So this is what a letter of demand is. And from my understanding, it's not prohibitive to find a person who sent it or to even put together one yourself. Right? So maybe let's just unpack that a little. And this applies to not just defamation situations or Google reviews, but also all sorts of demand situations. How different is it when an individual sends a demand notice or letter and a lawyer sends it? Is it really so different where the lawyer's letterhead appears?
Well, I would say that if you send it if a lawyer sends it, the publisher would, I guess, tend to think that the claimant is more serious about the claim. Right? I think for the general public, you can think of it if two letters exactly the same content. One is sent by Ivan, and then the other one is sent by Tembu Sulo. Right? The letter from the law firm is going to hold more force. It's going to hold more weight. It's going to make the publisher rethink its actions.
But if we break it down to its component parts, it's really a matter of impression, right?
Exactly.
Because whatever is stated in Ivan's letter and the law firm's letter is exactly
identical.
The same thing. Making the same demands, making the same allegations, assertions, right? Taking the same position. It's really just what is the impression of the person reading it. Okay, good. Okay, so that we can move on. And then how about this thing about damages then? So say claimant now wants to hair salon, restaurant, whatever, sending it to the ex-customer, former customer. I point out that you've said this against us, about us. It's not true. I give you a chance to remove it. I also want you to pay me X. How much is X? And how does one go about, or rather, how does a lawyer go about advising or calculating what X is?
The way we do this is usually by looking at precedents, right? So what has a court decided in a similar case previously? Because ultimately that is what
Past
you're going to
cases.
be looking at when you make your arguments in court.
Sure.
Yeah.
So it's track record basically.
Yeah,
in a sense.
Yeah, you're trying to find the most similar case you can in that has been decided
Similar
before.
profiles of persons or companies.
Similar profiles, similar type of allegations that were made. We look at the seriousness of
And
allegations.
you use that to try to estimate the size of the
Then you have the
damages.
range, and then after that you argue on why this case is more severe, right? And then that's how the court comes out with their final award on damages.
So not really so difficult to estimate. Meaning that there is a method to it.
There is a method to it, yes.
Okay. And also it also means that you can't simply state what I feel I deserve
No,
as a matter of opinion.
You can't. And I have to say, I feel like the general public's perception of how much you're entitled to for defamation is always tends to be a bit unrealistic.
So without holding you to it, but really, man on the street, salon in the heartland somewhere, 5 to 10 years of business, fairly well known in the neighborhood, but not the top in Singapore, right? For somebody like that, what would their reputation be? And we can just generalize it. Are we talking 10,000 and below, 50,000 and to 100,000, or more than 100,000?
Okay, it's a bit difficult to go off generalities.
Yeah, but maybe you can use your own range.
Well, okay, I think if you're talking about business, one place we can start at is looking at whether this comment had any effect on your business or not. We can look at your financial statements. Right? After this post came out, did you suffer 10% loss in your business? Because that's potentially claimable as well.
Sure.
Right?
Or maybe in the case of a restaurant, after this bad review was promoted or publicized on social media, 40% of my bookings and reservations all cancelled.
Yeah.
That's a very clear example of how that took.
Yeah, and now you have actually records of how much damage, how much losses you have actually suffered, right? So these are business losses.
But that's a different component of the damages, right? Which is the loss of business. But how about just reputation, damage to reputation alone?
Well, damage to reputation becomes a bit difficult as well because you have to consider things like, do you even have a reputation to start with? Right? How great was your reputation?
Yeah.
And we also have to look at the statement. How damaging was the statement? Right? So it becomes very difficult. But I would say in most cases, you're looking at under 100,000. If you're talking about a business that has a track record or has been in the industry for long.
Okay, making you stretch a little, would it be even less than 50,000 on average? I mean, and on average is such a general statement, right?
Yeah.
But by and large, for, as I said, right, a heartland small business, provision shop, even, let us say, would you place that, again, complete step in the dark?
Okay, for most reviews I've seen, yes, I would say it's under 50,000.
Yeah. And the reason why it's a pointed question, right? Because this is the difficulty that we encounter, and I speak only for myself. I can't imagine what other lawyers might say, but the cost of bringing a claim, and we talked about this in our previous episode, the cost of bringing a claim to receive 50,000 might require you to spend 50,000.
It'll be disproportionate. And that's usually what I tell my clients for defamation, especially where the defamatory statement, to my mind, is not that damaging, right? It can be damaging, but for most of the cases, I'll tell them it's not going to be worth it, right? We can try and resolve it amicably with the publisher.
Yeah.
I have a chat with him, tell him remove the post, and we won't have to comment on all these things.
Yeah, I think I have something to say, but not as a question, but as a statement, and I just wanted to hear, and you don't have to agree, but I just wanted to hear what your thoughts are about that. Very often, my own thoughts, I'm not saying this is what I say to people who come to us for inquiries, but my thoughts as a business owner myself is, what do I really want? Right? What I really want is firstly for this to stop.
Yep.
Okay, that's the first thing, and it's separate from wanting any sort of recovery of compensation. I just really want it to stop. I don't want it to continue. And second is I want to recover the reputation that I have. Right? And what could achieve those two things is simply for the person to stop, and that could happen without me even doing anything because they just get tired, or they have already achieved their objective of saying something that was very aggressive and it got shared. But the second is, and this could come with a bit of effort in terms of engaging him, if there can be an apology or a clarification from the publisher or even from the business, that could also recover the reputation or repair the reputation. That doesn't sound like it's taking legal action, but I think, in my view, that's taking practical action, practical steps to do the same thing or similar thing.
Yeah, I mean, I think I encounter that quite often as well. If I look at restaurant reviews, I tend to search by lowest, and I'll see how the restaurant responds to negative comments. And a lot of times, reading the restaurant's response, I tend to take the side of the restaurant. Right? So I don't think you need to resort to lawsuits at the start. Try and resolve it first.
Yeah, and just by saying, I mean, there's so many ways to respond. Sometimes a way to respond to one response is not to respond. That's also a type of response. And the reason why I say that is, even though it's very hard to imagine, because even as a person who uses businesses and other service providers all the time, you would expect that they'll be professional to do it. But there are some comments that shouldn't be dignified with any sort of other comment, because it just continues the conversation. Because they're so obviously wrong or one-sided, lopsided or inflated, that it doesn't even require any other clarification. Would you agree?
I mean, yeah, and I think in those kind of situations where there is, I mean, it's clearly a malicious reviewer that's out to damage the business, then okay, I would say legal action in such circumstances might be warranted, right? Just to prevent the harassment from going on.
Sure.
Right? But in most cases, if you're talking about a Google review, where it's just one post, and I think after that first post, the reviewer can't add on to it. Maybe you can just edit the post. Right? That's about it. I would say in those kind of circumstances, first thing maybe you do is provide your response on the Google review itself, so that the public can see your side of the story. Right? If you're still not content with that, then okay, you can get a lawyer to send a letter of demand, or you can send it yourself asking for the retraction of the post. Just delete the post and everything stops.
Sure. Which then leads me on to the next point, which is stopping it is the most important thing.
Yes.
I think recovery doesn't always have to take the shape and form of compensation, right? But as long as the reputation and the impression is recovered in the eyes of either existing or future customers, I think that's the job done. And then the third one, the other point is having some sort of donation to charity, which is very common, right? Or making a public statement to say that we maybe agree to disagree. Sometimes that is also done, where neither side needs to give up too much ground. Right?
And that's usually what you try and reach during settlement negotiations. Right? Most of the time, what I see in defamation claims, business sends a letter of demand, remove the post and pay me 5,000, for example. I'll write back and say I'll remove the post. I'll send a strongly worded. If my client it didn't make a defamatory statement, send a strongly worded defense to that letter of or response to the letter of demand saying why my client is not liable. I'll send a separate letter as well saying, and this year, we remove the post. We don't make
as a good middle ground.
And this is just so we don't have to go through the entire set of court proceedings for next year or next 2 years.
So you just talked about the second point that we raised earlier. First is, what does a demand letter look like? How does it work? Why is it helpful? The second one is negotiating a middle ground, resolving it, peacefully, amicably, with both sides getting enough what they need. And then what happens when that doesn't work and people then do need to file a claim? Let's start with which level of courts would it likely be?
I think for most cases, this will be in the state courts. Right? So if you're looking at anything below $250,000, that will be in the state courts. Right? In most cases,
vast majority.
I think the public tends to have unrealistic expectations. I think they look at a bit too much of US cases, Johnny Depp and Amber Heard, 15 million damages.
Wow.
That doesn't happen in Singapore. Right?
So anything from district court and below?
Yes, generally, in most cases.
Now the second one would be a second part of that would be, without going into too much detail, what are the steps then? Can the business owner take action on their own, or do they have to engage a lawyer? And this is a good time to bring up the fact that a corporate entity may sometimes need to engage a lawyer.
Oh, I'll say most of the times a company has to be represented. So if you are a business trying to commence a defamation claim, you more likely than not, you have to get a lawyer to file it on your behalf.
Yes. Okay, and then what will follow is a whole sequence of paperwork process called attendance.
So,
Just legal work and legal fees, basically.
Yeah, so just for a start, statement of claim goes out by the claimant. You will appoint your lawyers. If you're in Singapore, usually within 14 days, if you intend to appoint a lawyer. And then 21 days, you will file your defense. And then that kickstarts
which really ends with this contest called a trial, right?
If it goes all the way, you go for trial, and a very stressful experience.
Where you need to have evidence, and you need to maybe prove these things. You need to prove that the statement was made, that it was published, third party, defamatory, no defense exists, and basically you go through the entire exercise of justifying.
Sure. So there will be the legal side of it, but there's also the emotional side of it. Like being on the stand is never a pleasant experience.
Yes.
You're basically being interrogated for maybe a day, 2 days.
And I want to come back to this point that revealed itself. A corporate entity, which is vast majority of businesses, unless you're a sole proprietor, right? Private limited, LLP, any sort of corporate vehicle will have to engage a lawyer. And that means that usually some people who think that, well, it's okay, I can save some legal fees and costs by doing this myself. That option is not available to a business.
Not available
90% of the time, maybe even more.
Yeah. And even for individuals, going through the entire court proceedings.
So it means that
difficult.
It means that even before any cent is received in your hand, you need to earmark and budget, at least a fairly decent, sizable set of legal fees.
Yeah, and I don't think it's very uncommon for you to go through legal proceedings and then have a settlement midway, and a lot of times settlements are just withdraw your post or give me an apology and I won't claim a single cent from you.
So it sounds like, and I'm just trying to summarize this portion of the chat, which is us looking at the situation from the standpoint of the claimant, the business owner. You're not saying that every case, most cases are not worthwhile. You're not saying that. We're not saying that. But we are saying that very often, pragmatics-wise, it may not make perfect sense or so much sense to pursue it.
Yeah. So if your objective is just to get the review removed, I think most of the time you don't need to go all the way.
Maybe for that. Communicating directly, I would say, which is a lot more, which is a more progressive, enlightened approach, unusual.
So that's something that courts encourage as well, right? So
reach out directly and say, look, you're unhappy about this. Can we make it right and not?
Oh, not even that. So right now, the pre-action protocol for defamation claims, I would say it's strongly encouraged for you to send an offer for mediation, right? So that I think that comes from the courts.
So resolution is embedded into the entire process.
Yes.
They really don't feel, they meaning the administrators of the process, don't feel that this is the best use of anyone's resources.
Yes, I think the courts have seen that the vast majority of defamation
it's a legal right that exists and you're fully entitled to protect it, preserve it, and do something about it. But if they
be smart about it. If you can resolve, if you can achieve the same outcome before starting the suit, do it then. Don't pay your lawyers, waste 6 months, and then reach the same outcome.
So let's maybe start to wind down by talking about the other perspective. Man on the street, went to the restaurant, big occasion or otherwise, disappointed. Leave a honest review. But it is a bad review in the sense that it is a negative review. But bad is not so accurate, right? It's a negative review because you're saying something that's critical. You might even say to others, I wouldn't come here if I were you. But for many of those people, and these are the people that sometimes also reach out to us for help, they're not flush with money. They really didn't go out of their way. And let's assume that they are not malicious or vindictive. For that person to receive now on the other flip side, a letter of demand, big law firm, threatening all sorts of things, asking for astronomical figures. And I know it's a tough situation to generalize, but would you then say or suggest to that person who receives that letter, number one, don't panic? Or what would you say?
Yeah, that's what you tell them, right? So, I mean, they are entitled to their opinion to leave a negative review, right? If people weren't allowed to leave negative reviews, there'll be no point in having a review system. Everybody will be 5 stars, right? So you're entitled to your right to criticize the business. But at the end of the day, you have your freedom of speech, but how much is that worth? Are you willing to go through a year of court proceedings, spend money on legal fees that, at the very minimum, right, go through an entire set of legal proceedings,
Sure.
20,000.
But this time around, remember we're talking about the flip side where this is the customer.
Sure.
The customer who may feel that he was doing everybody a service, a favor,
Sure.
by just putting their opinion out there. Because that's how the whole review system is meant to work. We're supposed to get a broad variety and spectrum representation of views and experiences. Now, would you say to that person, don't panic too much. Whatever the figure is that comes on that piece of paper, you can be somewhat assured that the person claiming it is just trying their luck. I know, again, it's a bit of a stretch.
Okay, I usually
But
tell my
what would
clients
you-
something along those lines.
Yeah.
But I mean, firstly, I make them aware of how much it's going to actually cost if we go to court. Right? After that, I'll follow up with if you can remove the review and not have to spend
Yes.
this 1 year and X amount of legal fees.
Yeah.
Are you willing to do that?
Yeah.
Most of the cases, they say yes.
The
right?
reason why I asked that, sorry to interrupt, is that I think removing it is not the problem. The problem is, or the challenge is, even after the user has eaten humble pie, meaning the review was actually genuine and honest and legitimate and justified. But to smoothen things out, the customer and the publisher has humbled himself to say, okay, you know what, I will remove it, even though I feel I'm right. But the claimant is not satisfied, and they're going for the jugular, they're going for their pound of flesh, to use that turn of phrase. They want their pound of flesh, and unreasonably so. Now, what would your thoughts be in a situation like that?
Well, it's the same thing, right? I think I said previously in the podcast, usually my response would be 2 letters. The first one would be your response to the claim. Basically, I mean, it can be anything, right? This was my opinion.
Yes.
It's based
I'm
on the
entitled
facts
to
that
it.
I perceive. I'm entitled to it, right? I reject your claim.
First letter.
Second letter, notwithstanding my positions in the first letter, that I'm not liable, I'm willing to settle this matter amicably by removing the
Yeah.
post. Send those 2 letters out, see what the business, the restaurant's response is.
Yeah.
If they still intend to remain unreasonable,
Yes.
then I have to go back and tell my client, I'm sorry, looks like they're going to be suing.
Yes.
We'll fight it out in court.
Yeah.
Right? But now that I have this letter saying that I'm willing to remove the post, if I eventually succeed at trial, the court is going to look at this letter and, let's say, punish the restaurant. Because
and
the
say-
restaurant should have settled earlier on.
Yeah,
They
say, look,
benefit.
he
Right.
already made an apology. And I think this is something that is a topic for another day, but lawyers like you and I also have a very important task of right-sizing the claim and not giving too large or too small in terms of size the expectations to the claimant, right? Because if it's overly inflated in terms of ambition, expectations, and outcome, they might go through the entire process and then not recover anything close to what they envisaged or wanted to at the very start. That is the quintessential worst case scenario for everybody. Everybody's been dragged through this with no real outcome for anyone. And maybe that's a nice place to start to wind down. So in summary, you know, when any personal insights or professional insights you would be able to share with people on both sides. Maybe let's start with claimants. What should they bear in mind the next time a business owner or small business or large business or anyone with a review or presence encounters something like this? Something that is a bit more cutting, hurtful, unpleasant. What would you suggest that they go through?
Well, I would say firstly, take the negative feedback as constructive criticism. If you don't agree with the feedback, you can always leave your response on your Google review page. I think a sound and well-crafted response usually does a lot to mitigate any sort of reputational harm. Right? If that still doesn't work, sure, consult your lawyer, get advice on whether the statement is defamatory or is it a rightful opinion that someone's entitled to.
And also the cost of pursuing this for
Yes.
the entire distance.
Yes, because I mean, if you just jump and shoot the gun, the reviewer might
stop.
make a
Yeah.
no wait, the reviewer might edit the post and say, this restaurant has sent me a letter of demand from lawyers for leaving a review. And how bad is that going to look?
Yeah, which is further escalating and prolonging the whole discourse, the whole conversation.
Yeah, I would say you have dug a deeper hole for yourself.
So that's on the claimant side now. For the person, for the user, the publisher, what would you say?
Make sure your criticisms are always anchored in facts. Right? If you don't know whether something is factual or not, don't speculate. I mean, you can use words like I believe or I think, but don't express something as a fact if you don't know whether it's actually factual or not, right? The Wagyu example that I gave earlier on, right? If you are not 100% sure that what you're served is not Wagyu, don't say that the beef is not Wagyu in your...
Because you have no basis of saying that as a matter of certainty and fact.
Well, I mean, that comes down to defense of justification, right? It's on you to prove that the steak is not Wagyu. And how are you going to do that as a customer at the restaurant? Unless you took a sample of the beef or you have photographs.
Yeah.
It becomes a bit difficult for you.
But I like what you said about, taking it constructively. But is there anything in a similar vein that you would say to the publisher as well? Anything that you would say, look, you're entitled, you're fully entitled to express your opinion, and you're doing everyone a favor as well by expressing sharing your experience. But there's a limit also to...
Well, I would say just don't sling insults.
Okay, don't sling insults.
Right? Keep it factual. Keep your opinions, let's say, a culture, right? Don't be aggressive. Don't call names. Yeah. Don't allege things that you can't prove in court. Right?
So in keeping with that, and then the last thing I want to say, and I don't know what your thoughts are, is I always say, in a situation like this, try to take the high ground, even though you don't have to. You're legally entitled to stand your ground and fight back on both sides. But sometimes, again, but this is a very subjective thing. It's just the way I see the world. Better to take the high ground. As the business, I can do better. I can always learn.
Yep.
And I'll maybe, be more circumspect the next time I encounter a situation like this. I'll do better. And I want to. For the customer as well. As long as if you genuinely want them to improve, then say things that allow them to improve. As opposed to say things that are only hurtful.
Yep.
That brings us very nicely to the close of today's session. I really appreciate you sharing your insights. So we got through the time so quickly, and I'm looking forward to the next session. Ivan, thank you very much again for sharing all your experiences and your time with us today. Tell us again, where's the best place for people who haven't connected with you yet to find out more about you?
You can drop me an email at ivan@pdlegal.com.sg.
Otherwise, LinkedIn is a great place to connect with Ivan or myself or any other lawyer I think you're trying to reach out to. Thanks again for being with us here today. If you like what you heard and you want to hear more, follow and subscribe for more legal things.